Thank you, Bell, California.
Mr. Bagley, Jensen.
Maybe we could have an in-service on actuarial speak. Yes. I'm
Make
just
you go to sleep.
We're required in our audit to show both any liability as an actual line item in our audit. We're going to be fine. We had a conference call 2 weeks ago with the firm, the trust that is managing our post-employment benefits. We're more than 167% funded in that actuarial number. So there isn't a risk, but it just takes time for these third-party actuarials to get the information from OPEB or PERS, do their study, send it to us as an independent third person, and then have Mark do his review and include it in the audit.
Will the person or company that does that actuarial report come to the board and make a presentation on that?
We haven't done that in the past. I can talk to our auditor and we can present you the information we got from OPEB, the trust that shows where we stand, you know, in terms of our percent funding. It's a complicated sort of analysis. The OPEB assumes that there's a long-term return of 7.5%. OPEB, I think, last year, 12 months made 9.3%, and we're like 167% funded. So we're well capitalized, and OPEB made more money than their assumed long-term rate of return. So it's a very good, positive report, and I can put some of that together for you if you want.
Well, my question, I thought we hired someone to do this for us.
Yes.
Can they come in? And as Russ says, you know, this is something kind of new, and it would be nice for all of us to know exactly what's happening.
Having had to sit through an actuarial report with CSRMA every 2 years, it's not really something I would wish on there. They are complicated, and let Jeff summarize. That would be great for me. Thank you.
Anything further on item 15? Hearing nothing. 16 we've done already. 17, staff reports, operation and administration. The reports are before you. Have any questions?
No.
Seeing none.
No,
Mr. Green?
I don't remember if it's in this report, but I noticed that there was a accident report of some type and had 60-some-odd days lost. And I don't remember the details of that. Was that an employee injury?
On
believe it was,
17,
Brenda.
it's on 209 or 17-9.
That's not new.
No, it's not new at all.
We did have the employee had a shoulder injury moving a manhole. So we found
Okay, this number of days lost, 55.
they were out of work for 65 days.
And how long ago was it?
It was about a year ago.
Almost, not quite a year ago, that's why it's still on here. It was, yeah, it's almost been about a year, because it was about the starting of the fiscal year last year. So that's when it's still on.
And how long do we carry that?
Well, next month, we will be into the new fiscal year. This is reporting June, so you won't see that next month.
I mean, it's so unusual that we have a work loss injury that I was curious about on this.
Would it make more sense to have this coincide with the OSHA required reporting period? You know, it ended at the April 15th time period versus carrying over on this.
Well, this affects, our injuries affect our fiscal year workers' comp costs. So that's why we've always kept it with the fiscal year.
Understood. Thank you.
Anything further? Seeing none, we'll move on to committee reports. Thank you there. Any questions on any of them? None?
I can just say that the CEQA committee got into a number of areas that were very productive in terms of understanding that whole process. Will elaborate on that?
So we met and talked about the CEQA process that we follow as it relates to projects and where our projects fall in terms of being a ministerial project, being an exempt project, or requiring some sort of environmental review. And a majority of our normal maintenance projects like these, lining, top hats, manhole coating, spot repairs, fit within an exemption under CEQA, meaning that we're exempt from having to do a full-blown EIR sort of environmental analysis. The treatment plant rebuild was a full EIR, the Ventura Avenue project was a full EIR, the Baldwin siphon drilling under the creek was a full EIR. And so depending upon the project description and the impacts of the project, kind of dictates whether we're exempt or whether we have to follow a full EIR. And so I thought it was a good conversation about the types of projects we do and where they fit, and the outside resources we use in the event that we have to do an EIR. If we, whether it's vehicle trips and noise or light or impacts to birds or lizards or fish or even cultural or historic resources, we'll bring in the experts necessary to make sure we itemize what the impacts would be, and then you, the board, get to ask questions, the public can ask questions and comment on it, and make sure that all our projects are sort of methodical and transparent in the process. CEQA is not a project approval mechanism, it's really just a disclosure mechanism for the public and for the board, the lead agency, to be able to clearly understand the impacts a project would have before it moves forward. So at the end of the meeting, we got into some discussion about some of the processes that particularly the city of Ojai follows when it relates to encroachment permits. When we go work in their street, they're asking for sort of another additional level of cultural resources analysis. And so we would follow that process because we're working in their streets under a encroachment permit. And so we're going to come back with some additional discussion to the CEQA committee on a couple of items. And if that follows through, then it'll come to the board for discussion and approval, specifically about sort of formalizing a couple of things. One, anytime we're digging and we find a bone, we're required by law to stop and call the coroner. We're not qualified to decide whether it's a chicken bone or, unfortunately, potentially a human bone or a horse or anything else. And so a couple of those things, the committee asked us to come back with some specific language that would sort of formalize those sorts of legal requirements. So we'll go ahead and do that.
Thanks, Jeff. Anything else?
One thing connected with it that did trigger us discussing the need to expand the good practices part of our review of projects, because we very often have to use acceptable practices, and there's no written guidelines on some of those. So I think it was a discussion to do with expanding or clarifying some of our management practices.
Well, I think that's what we'll come back to the committee with, some discussion on some best management practices and putting those in writing so that it's a little bit more formal.
Thank you, Mr. Green. Director reports on meetings, seminars, and conferences. Do we have any meetings attended? Items of interest, correspondence, or articles? All right, board member comments. Mr. Ulrich, I believe you had some comments you'd like to make.
I do. And as I was contemplating these comments, I was reminded that it was about a year ago, matter of fact, it was last July, that I stood before this board presenting my credentials for a vacant District 7 position on the board. But that's not what I'm care to comment about this evening. In reading the June 26 minutes of the regular board meeting that we ratified and accepted this evening, and notwithstanding some of the referenced objections to several board members, in the interests of good and prudent board governance practice, I would like to request that the following item be included on a future agenda, actually preferably on the next agenda of a regular board meeting, and for discussion of the regular board, a review of the A to Z legal professional services agreement, comma, a regular, that is monthly or as submitted, board review of the A to Z legal services invoicing, such that the board can be apprised of the specific activities of the district council and for which the district is being regularly billed. This in no way reflects any dissatisfaction whatsoever with A to Z or Attorney Kwan or any professional services as rendered, but is a sincere interest in prudent and transparent public agency governance. That's item number one. Item number two, and this references the June 6, 2017 Ojai Valley Sanitary District letter to the Ojai City Council. While this letter appeared to be ratified by the board at the 26th June regular board meeting, I personally did not appreciate that a letter, which was generated by the general manager and with the assistance of the district legal counsel, was sent out to the Ojai City Council, that is another public agency, in the name of the district board without first having direct board input and approval. In my humble opinion, anything that purports to speak for the board and its individual members should be first brought before the board for our discussion and approval. Item number three. At the 26th June meeting, regular board meeting, Council Kwan engaged in a district legal analysis of the impact of Senate Bill 1069 and all of that. In his analysis, Council Kwan referenced several different California government and health and safety code sections and included multiple references to the controlling influence of chapters 4, 5, and 7, along with what, upon my reviews, and I listened to the audio several times, appeared to be a conflation of California Government Code Section 66,000 and Code Section 6600. Also, there's a reference to Code 6400, without distinguishing that these references were now being made to the California Health and Safety Code, etc., in several of his comments. Please note that the inclusion and definition of the district as having been formed under section 6400, the Health and Safety Code does not render the district somehow exempt from the other sections of the government code, and especially where the code may relate to collection of fees. Further, there were 2 instances from the audit record of Council Kwong mistakenly conflating section chapter 5, section 66,000 fees, and chapter 5, section 6400 Health and Safety Code, formation of special districts. In addition, California Government Code section 66013, section 4 defines a local agency as defined in section 66,000, which Council Kwong indicated was not applicable to the district. I'm confused, the audio record is confused, and I'd like it clarified. This extended to my query regarding Government Code section 66013 and the applicability of section 65852.2 at sec of the Government Code. Although I listened to the audio record of the June board meeting several times, I was unable to fully follow Attorney Kwong's legal reasoning and was left with the belief and understanding that the district's legal position relative to Senate Bill 1069, Government Code Section 58532 at SEC is founded upon an interpretation, a legal definition, and what may be described as a legal opinion based upon a technicality, that is, which may not resist the light of day, subsequent legal review or action of the legislature of the state of California. I'd like to have that clarified, if possible, in a manner that is accessible to myself as a board member and the public. And then finally, several of my constituents have business before both the board and the district. In my opinion, the manner in which we listened as a board and responded as an agency, the June District Board meeting demonstrated a defensive and bunkered up posture that left my constituents, who are all in fact ratepayers of long duration, feeling unheard and somewhat abused. While their concerns were undoubtedly addressed by both the general manager and district council, the manner looked and felt like a brush-off. Just because we may disagree with their positions, the manner of the denial was absent a human component that we all need to share and demonstrate. In addition, the legal basis for the denial of my constituents' request, and by way of explanation of the district position, and in reply to their queries, was explained by Council Kwong, and I addressed that in the item preceding. That's the end of my comments. Thank you.
Thank you, Mr. Orr. Any further quotes? Mr. Green.
Well, I guess we have to respond to your complaints, and I think we have to ask that we do that.
Well, I can start. If you look at the government code, Title VII in the government code is for planning and land use. That is where 6600, section 6600 is. This agency is established under the Health and Safety Code and does not have land use authority whatsoever. So nothing in Title VII, planning and land use for the government code is applicable to this agency. I don't know how many times we have to say that, but that law does not apply to us. You can't use it as it applies to us.
If I may respond to that, you're saying 6,600 or 66,000?
Whichever one you talked about.
I talked about, you made reference to both of them.
It has to do with planning and land use.
Right.
And that's what everybody is sort of hanging their hat on for including special districts into the collection of fees for charges.
Well, I'd just like a clarification because in 66,000, which appears not to apply to the district,
It does.
a development project, this is 66,000A, subsection A, means any project undertaken for the purpose of development. But a development project in that subsection A is defined as including a project involving the issuance of a permit for construction or reconstruction. I would submit that that actually does affect. It's a permit. And the
Doesn't apply.
distinction,
I'm sorry, Bill, you're just wrong.
well,
You
you
need
know,
to go talk to an attorney.
we'll have to agree to disagree.
Okay.
I'm good with that.
I have a question. Mr. Kwan, in Director Ulrich's extensive query, did bother contacting you at all to become further educated on this whole matter?
I'm sorry, could you say that one more time?
Yes. In Director Ulrich's extensive query, did he bother to contact you to get further educated in this whole matter?
No, I have not spoken to Mr. Ulrich since the June 26th board meeting. He has not contacted me about my opinion, has not requested it in writing, has not requested me to explain my references to certain code sections. No, he has not.
So we can only surmise then, based upon that, the reason for the orchestration of this, grandiose type of exposition is to gain the attention then of constituents and so forth. I find it kind of suspicious in a lot of ways that whenever the city does not like certain types of responses given by their city manager or by their council in the past, oftentimes what is the resorting type of consequence to those people is they get fired. And, I feel that there's kind of a sense of that happening right now because certain types of opinions were not appreciated, were not liked. We have a small select group that unfortunately likes to orchestrate this up to a circus. I'm not one of those board members that likes a circus. If anybody here, would like to argue sufficiently by contacting council and presenting something, please, by all means, do that. But we have a council here that's responsible for this entire board. Not just one select director trying to represent this charade, in my opinion, that's going on. It has been going on far too long. So unless there's something else that can be presented to this board here that can convince us otherwise, this particular council here is our council, and he provides us legal opinions. And it's basically not appropriate for somebody to be acting as counsel here, trying to give their opinions about something in a legal matter, because we're responsible to our constituents based upon the opinions that our council gives us. And that's my opinion.
Bill,
Mr. Green?
I don't think we've ever had an understanding of whether or not individual members of this board were in a position to contact our legal people, outside of regular meeting. Am I wrong? I don't think that that's ever been a process we've used. So, I don't know what the proper approach would be, except you brought up issues. I think that we should put them on an agenda and ask that they be answered by our council.
Thank you, Stan. Relative to Board Member Kaiser's opinion, I share some of those considerations. However, each and every one of us owes a responsibility to our district and our constituents. And the references to what I shall refer to as speculative interpretations of the intent and interests of my concerns is, as well as this is the second time that the suggestion has gone forth that I need to address a particular concern off the record with staff. And the reality of the situation is we're a public agency, and our deliberations and our queries and our interests should be open to the public, as well as to a certain degree, with an element of respect to each other. Thank you.
In regards to that, Mr. Ulrich, I appreciate that, frankly. And I believe this board does go above board in being open to the public. However, if one has attended special district governance courses, they would understand what is their responsibility as board members, individually as well as collectively as being part of this board. Now, I encourage you to contact Brenda and find out about those courses in the Special District Institute.
Yep.
Mr. Bagley?
Robert, got a question for you.
Sure.
Anything I said to Director Ulrich incorrect about planning and land use as it relates to cities and counties and their police power for planning and land use?
I heard what you said, Director Baggerly, and I didn't find anything legally incorrect in your analysis of the law with regards to the government code sections dealing with land use and planning and zoning laws, and with regards to the health and safety code by which this organization, the Ojai Valley Sanitation District, receives its authority by the state legislature.
Thank you.
Any further comments?
So can we get a scheduled discussion about this at a board meeting and put it on the record? Would that be the right way to do it? I mean, we're having a discussion now, but I don't know where it goes unless we're going to reach a conclusion based on this discussion, and I don't think we can.
I've reached mine.
Yeah.
And also the same thing, I have the same opinion. We listened to our attorney explained what it was, how it affected us. The only way this is gonna be resolved is to take it to the courts. If that's what you want, if you want that kind of thing, take it to the courts. Because this thing is going to impact every agency in the state of California, every city in the state of California.
Well, we've had legal opinions.
We had our legal opinion, yes.
Right? We've had our own board members question that interpretation, and I think we should respond by getting our attorney to respond to those questions. And I'd like to see that done in open session here. So could we put that on an agenda and answer the questions that have been raised?
Have not we already done this thing in open session
I
with the public?
guess not.
No, we did. This was just done recently.
Well, if there is a question in the mind of somebody here about that response, I think we can repeat it, or we can clarify it. Why would we just ignore it, and say, well, somebody's not happy, but who cares?
I guess I'm gonna jump in here from a procedural perspective. The board hires legal counsel. Legal counsel has given you an opinion on something. There's a question about that legal opinion. And I guess my concern, and I need Robert to step in here, is where does the board and or individual board members that may disagree with a legal opinion, no matter what it is, where do we go in terms of sort of voting on, ratifying a legal opinion, and how does that all work out? Because and how many times and do we have repetitive meetings to talk about competing legal analyses and on a topic? Yes, we've got a topic here before us, but it raises an important question about sort of a legal opinion and how the board either accepts or modifies or wants that legal opinion clarified. And so I think there's a procedural question here about how that all works out when it's a difference of reading or legal opinion about something that is before the board for discussion.
Chair?
May I respond?
Yes.
Through the chair to General Manager Palmer's questions and analysis. I think he makes a good point here about at what point in time does a legal opinion have to be retread or reanalyzed after it has been given here. And that's why you have a board of 7 board members. And there's no requirement that there's unanimity on every single point that your board takes action on. So long as there's a majority, the majority rules and moves forward. If someone disagrees with that opinion, that is their full right and to do so. Whether it's based on a legal opinion or a factual analysis or whatever, they can disagree with that. So the fact that there needs to be some unanimity or some retread of that analysis is not really necessary because that's how this democracy works in this case. I think it'd be important to find out how someone voted on this matter. If receiving the minutes was some indication that the minutes were correct, then how did you all vote when you received that on the consent calendar today? What was the vote on the consent calendar?
It was unanimous.
It was unanimous. So there was an opportunity to express an objection to that, saying that those minutes are incorrect for either a legal reason or a factual reason. But there was a unanimous decision by your board to accept those minutes as they constituted. That would also mean a unanimous acceptance of the audio tape of that meeting where I gave my opinion very clearly with regards to those code sections. Again, you have the ability as the directors of this agency to contact legal counsel and say, can you just help me out on these questions? Can you just clarify this citation? Can you give me a little bit more understanding of that? And I have, as a matter of fact, answered individual questions from some of your board members on an individual basis. There's nothing against that or improper about having that contact with your legal counsel. I'm here to assist you in understanding the law. So that is clear. So how many times you want to do this, I guess it's really up to you. You can re-agendize this because that's within your authority to do so, and to redo exactly what Mr. Palmer and I did on June 26th. You could just re-agendize that again and let's have a redo or have a repeat of that same thing. That's really your call. I'm not going to get in the way of your discretion to do that.
Thank you, Mr. Cohen. Mr. Bagley?
Robert, you keep track of me in case I go over the line here. How many board members want to hear this again? Raise your hand.